Hey everyone, welcome back to the Irretrievable Breakdown podcast where we discuss all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and I am joined by my co-host and the managing partner of our firm, Nicole Bikakis. And today we are going to discuss the role of the guardian ad litem in Connecticut family court. Nicole, why don't you tell me how your week is going so far? We're recording here on a Tuesday. Usually we record on Mondays, so I've thrown you a bit of a curveball.
I know now. I have to remember my weekend from a few days ago.
Or you could just tell us how your week's going so far if you're off to a hot start.
I mean, so far so good. We've had beautiful weather, I feel, here, so it's been fun to be outdoors. And we have some exciting World Cup games upcoming in the final this weekend, right? So
Yeah,
I'm excited. It'll be fun.
nice.
How about you?
I just feel like I'm running myself a little ragged at the moment. I'm pretty tired. I'm not sure how this recording is going to go. I had a friend visiting from out of town and running on like 4 hours of sleep last night. My friend's gone, but back into the normal week. And yeah, I don't know. Just didn't sleep great last night. So
How much golf have you played in the last 4 days?
I did play yesterday afternoon and this morning. So being outside in the heat and not sleeping a ton, probably not a great combo, but here we are. And, hopefully we can fill people in on what a guardian ad litem is without making too many mistakes or without being too low energy.
I'm always impressed by how mostly guys that I know can play golf in the heat, in the sun, for 6 hours in the middle of the day.
Friday, my brother went 36 holes. I left early. I would have played 36 holes on Friday, but my daughter's daycare called in that they thought she had hand, foot, and mouth disease, which I don't think she had it. Allegedly somebody else in the class had it, but I'm thinking it was Friday afternoon. Let's let some of these kids get home early so we can take off early ourselves. There may have been a little bit of that. But
they're not the ones playing 36 holes of golf, so
yeah,
maybe they would like to take off a little early.
Yeah, it was probably good that
36 holes of golf takes how long to play? That sounds
good 8-9 hours.
What?
Yeah.
That's
I'm I don't love playing 36 holes of golf. I'll do it on Fridays sometimes to eliminate any temptation of even wanting to play golf over the weekend. Because I'll just golf myself to death on Friday. So it can be good for that.
Anyways, that's crazy to me.
Yeah. Well, one day, Tommy, your son, will be playing 36 a day. So let's talk about the role of the guardian ad litem in Connecticut family court. So Nicole, what is a guardian ad litem? And let's just start with that. What is a guardian ad litem?
So guardian ad litem is an individual the court appoints to lend their expertise and their input in typically a custody dispute. And there's something going on. The court is faced with whether it's a custody application or a divorce or a post-judgment custody matter that they're asking to be decided. And the court needs some additional information, an evaluation to be conducted, and they rely on guardian ad litems to conduct evaluations and provide recommendations as to what the guardian ad litem thinks is in the child or children's best interest in this particular case. And importantly, the individual that serves as a guardian ad litem does not need to be an attorney. It is often the case that the guardian ad litem will be an attorney, and the court issues a list showing what guardian ad litems are approved to perform those services in that court's jurisdiction. But it does not need to be an attorney. It can be a therapist or a co-parenting counselor. It does not need to be an attorney.
Yeah. But from a practical standpoint, like it pretty much always is an attorney. I don't think I've ever had a case where there was a non-attorney acting as a guardian ad litem. Have
Well,
you?
the benefit of having an attorney be the guardian ad litem is when it comes down to it, if you have to go forward with a hearing or a trial, that guardian ad litem is going to be cross-examined. Yeah, they're going to be put on the witness stand, direct cross, and they need it, having knowledge of exactly how to proceed in a trial or an actual hearing, and having those skills is a big benefit to a guardian ad litem, being able to really communicate their recommendation and defend the recommendation when it's being questioned.
Right. Now, obviously, the guardian ad litem does not represent either parent, but to be clear, they also do not represent the child. They are not just a conduit to advocate for what the child wants. They are there to advocate for what is in the best interest of the child, which can and often is different from what the child actually wants. There's a separate role where there may be an attorney for the minor child, also known as an AMC, and GAL is the short for guardian ad litem. But an AMC, attorney for the minor child, that is somebody who does step into the shoes of the child and actually advocate for what the child wants. It's pretty rare to have an AMC in a case. It's much more common to see a guardian ad litem who is involved to make recommendations about what is best for the child.
To your point, the guardian ad litem is also not a conduit to argue for what a parent wants. Sometimes parents think that the guardian ad litem should be essentially helping them get the result that they're looking for. But the guardian ad litem is a third party neutral. They're there to assess the situation and consider what's in the child's best interests. And also importantly, there is no attorney-client privilege that comes with the guardian ad litem's communications. Whatever the parents say or communicate to the guardian ad litem, whatever the child might communicate to the guardian ad litem, or what any of the other third parties that the guardian ad litem is going to speak to in conducting their evaluation, none of that is subject to attorney-client privilege.
Right. Now, a guardian ad litem is generally appointed when there's a high conflict case or the parties just are unable to reach an agreement. Sometimes that can happen in a relocation case or when there are mental health or substance abuse issues, or it could be, two perfectly normal parents who just are not able to reach an agreement as to what the parenting plan or what legal custody should be. And the guardian ad litem will come in to try to work with the parties to look into what's going on and hopefully help them reach an agreement. And if they can't reach an agreement, then they'll make a recommendation to the court. And we'll get into that a little bit more in this conversation. How does the selection process for the guardian ad litem work? How does that happen?
So typically, if you have a case where the guardian ad litem is being appointed, first is who's made there. You can make a motion to the court to appoint a guardian ad litem. So if one parent wants a guardian ad litem involved, then they can motion the court to appoint a guardian ad litem, and at that point, the court can choose from the approved list of guardian ad litems that each court has, and assign someone based off of that list.
Or not. They, just to be clear, they can also say, I don't think a guardian ad litem would be appropriate or helpful in this case. So just because a motion is filed, it doesn't mean that it has to be granted that request for a guardian ad litem.
Correct. But in terms of assuming they agree that a guardian ad litem would be helpful in this case, and oftentimes the courts will agree, unless it's a pretty straightforward issue and they feel like having the input and recommendation of a guardian ad litem just really isn't going to add anything to the analysis. A court's typically going to err on the side of getting the guardian ad litem involved, because it does, to your point, help in many cases. Parties reach a settlement without the need of first hearing or a trial, and just provides the court more information, more evidence on which to base their ultimate decision.
Right. And if the court is not inclined to appoint a guardian ad litem, the alternative path is to have the family relations office in the courthouse conduct some services. And that's sort of a parallel track to a guardian ad litem, except it's run through the state of Connecticut, where you're not paying for the guardian ad litem, which we'll get into that later as well. And that family services office can do similar things to what a guardian ad litem can do in evaluating the family dynamics, etc. So sometimes the court will feel that there's no help from a third party that would be helpful. That's pretty rare. Like usually the court's going to want some third party to come in and make recommendations about what should happen or offer some sort of service to help parties reach an agreement. But once a motion's filed, the paths are for a guardian ad litem to get involved or for family services to do some work with the family.
And whether or not a judge will opt for a family relations officer versus a guardian ad litem, sometimes that's really judge specific we're finding. Like some judges really want to rely more on the family relations office and have them conduct whatever services they can first. But other judges, especially where the parties are on board and agree that they want a guardian ad litem involved, having a guardian ad litem conduct the service versus the family relations office, which they're typically pretty inundated with cases and work. And so sometimes the level of work that is required on a specific case might be better suited to a guardian ad litem that may have more time and capacity to take on the specific case.
Right. And it can, financial resources can come into play also, where if parties don't have significant financial resources, the family relations evaluation or other service can be a more realistic option.
Correct.
But I keep cutting you off. So go back to telling us sort of how the selection works of a guardian ad litem and who is going to be appointed.
So you can have the judge just select from the list of approved GALs. That's one option. The other option is the parties each can put forth their recommendation for who they want to serve as GAL, or the parties can just agree beforehand amongst themselves and ask that the judge appoint a specific individual as the GAL.
Right. And usually if there's attorneys involved on both sides, they'll reach an agreement as to who the GAL should be. Because generally speaking, like you want both parents to buy in to the GAL and what their recommendations are going to be. So if you can get an agreement from both parents in advance about this person should be the GAL, it's just more likely to be helpful and more likely that the parents will kind of follow the recommendations and hopefully reach an agreement.
Well, and the other thing the court is going to decide is who's paying for the GAL's fees. And so that is especially true when, in certain cases, one party is the one who's paying for 100% of the GAL's fees, and you want to make sure the party who isn't paying for the fees feels comfortable so they don't feel like I'm not paying for the GAL and this GAL seems to be favoring the other person. That's why it's so important to have both people involved in the selection process when possible.
Right. So now that you brought up fees, so tell us a little bit about how the payment for the GAL works.
So the GAL will have their standard hourly rate. And so at the beginning, when the court appoints the GAL, they will also state what their fees are, and they will indicate who is responsible for those fees. So are the parties going to be splitting those fees equally, or is one party going to be paying a higher percentage, or is one party going to be paying all of the GAL fees? And so that's determined at the point of appointment.
Right. And it generally depends on like the financial resources of the parents. If they're in similar financial circumstances to one another, it's more likely that they're going to make an equal contribution. Or if they're married and this is a divorce case, they might have a joint bank account. So it, comes out of that joint bank account. And from a practical standpoint, like if parties are married, like who pays for it doesn't matter quite as much because at the end of the case, in addition to, the GAL will be paid, and then you're also dividing up all the assets. So, if somebody pays for more of the GAL, well, all of the assets that they have left at the end of the case are still subject to division by the court. So it matters less. And, people get more hung up on who pays what when it's a custody case where the parties have never been married, or if it's a post-judgment case. So, you already have your divorce or custody case has been finalized and you're coming back on a modification 2 years later and you don't have commingled assets anymore. In that situation, it's, parties sort of care more about who pays for how much of the fees.
Well, and if you're in a divorce and someone is financing the GAL through debt, then that does then become a little bit of a hairy issue.
Yeah.
But there's also the possibility too, if you're coming back post-judgment, and like, let's say you want to relocate and you want to get a GAL involved for the relocation, it might be because you're the one seeking to relocate and seeking to, bringing this motion, you may be the one responsible for 100% of the GAL's fees in that scenario. So it really is case by case.
Right. And not necessarily, like,
Correct.
you won't necessarily be responsible for 100% if you're seeking the relocation. Ultimately, it's up to the judge to decide if you and your spouse can't reach an agreement about who's going to pay for how much. Sometimes, another easy way to do it is to look at your incomes, and, do the contribution in proportion to your respective incomes. That can be an easy way to do it if it's post-judgment or in a custody case if you've never been married. So, Nicole, let's say the GAL is appointed. What does the GAL actually do once they are appointed?
So the part of the court's appointment, it will also list what their specific role and scope of their appointment is going to cover. So is this a comprehensive evaluation where this is which is common in custody applications or divorce actions, where the court's going to need to decide physical and legal custody. And so they have the GIL come in and have a broad scope, where they're going to look at basically the entire custody case and determine what is in the child's best interest for both physical and legal custody. The court can also appoint them for a more issue-focused role. So if it's like a specific parenting issue or scheduling issue or therapy issue or whatever if it's a limited issue, and typically on a post-judgment motion, you're coming back on a more limited issue, the court will articulate specifically what the scope of the appointment is and what they're really there to investigate and provide recommendations on.
Right. And once that scope is determined, the GAL will start to do the meat of his or her work. So they'll meet with both parents to understand sort of the history of the family from that parent's perspective, and try to understand what that each parent is seeking with regard to custody. They'll maybe meet with the child, depending on how old the child is. If the child's 2, they're not going to meet and talk to the child. It's not particularly relevant. But the older the child gets, the more likely it is that the GAL will meet independently with the child to talk to them about sort of the family dynamics, the history of the family, maybe what they want to happen with regard to custody. The GAL will also probably do a home visit to look at each parent's housing situation. They will likely observe each parent's interactions with the child. So they may go over and just kind of be a fly on the wall and watch them hang out with one another. Maybe they'll go out to a meal together or something like that. The GAL will also review any relevant communications between the parties. So, if they're nasty to one another, one party is saying the other parent's like always horrible to me, they can get in and review text messages, emails, things like that, social media posts, maybe text messages between the parents and the child. They also might talk to third parties. So they'll talk to the school potentially, or if the children are in therapy or the parents are in therapy, the GAL may talk to those mental health professionals. If DCF has been involved or the police have been involved, they will look into the records from the involvement of the police or DCF. They may talk to the workers or the police officers who have been involved. They may talk to the pediatrician and get an understanding of what the pediatrician, views as happening. And any other third party. So they really will just do a very in-depth look into the family dynamics, and sort of anything that is at all relevant, they will probably look into it if the parents bring it up. So that is sort of what they will do. And then they will use all of that information that they have gathered to ultimately make recommendations. So normally they'll sort of sit down with the parents together, or maybe separately share sort of their findings and their recommendations with what they think should happen with legal custody and what the parenting schedule should be. And they will, sort of explain the rationale, how they got to the conclusion that they got to, and then try to help the parents reach an agreement as to what their recommendations are, to see if they can sort of bridge the gap and get everybody to finalize the case once the GAL is involved. So, Nicole, do you have anything to add to that?
Yeah, just that. I think what you just said, they're on a fact-finding mission, really. They're going to look at, to get the full picture of what's going on. They're going to talk to whoever they need to talk to, look at whatever records are appropriate. Parents have to sign releases so that they can get authorizations to get school records, medical records, anything that is going to be helpful to the GAL to understand what is going on in this child's life. Because ultimately, the GAL is making a recommendation based on what they believe is in the child's best interests, which is, again, that same standard a court looks at in deciding the case.
Right. Now, Nicole, is whatever the GAL says, is that sort of the court order? Is it done once the GAL makes their recommendation?
No, it's just a recommendation. And the only person with authority to decide what the order is going to be or what the outcome is going to be is the judge, unless the parties are able to come to an agreement and resolve it together. The judge is the ultimate arbiter and has the power to make make it resolve.
So how much weight does the GAL's recommendation carry?
I mean, it still carries a lot of weight, unless, again, one party is successful in undermining the GAL's recommendation. They're able to kind of prove that the evaluation wasn't particularly thorough, or something was overlooked, or there was something deficient in the evaluation or the methodology the GAL used in getting to their conclusion. And that would happen. That would come out in a evidentiary hearing or trial. But absent really being successful in undermining the GAL's recommendation, the court is going to place quite a bit of weight on what the GAL is recommending.
Right. So before we part ways here, what should parents do if a GAL is involved in their case? How should they interact with that guardian ad litem? Let's say they were just appointed and the process is just starting. What are some tips that you have for communication with the GAL?
I mean, communicate with them respectfully always. Be prompt in the communications. They're asking you to fill out authorizations. They're asking you to respond to certain questions, and you need to respond to them timely so that they can proceed and get this evaluation done and get this case moving.
And it's also a reflection on you as a person. It's not just to keep the process moving. Maybe you don't want the process to move along for whatever reason. But if you are taking forever to respond, or you're very disorganized, that's not going to look great for you, because the GAL is just going to think, oh, well, that probably spills over into their parenting, where they can't be organized with the kids, and they basically don't have their shit together, for lack of a better term.
I mean, taking it seriously because it involves your kid. And
Right.
So what that translates into, if you're not taking it seriously or ignoring them or just acting like you don't care, that's going to translate in the GAL's mind into this parent isn't really taking their children's needs and into account very seriously.
Right. I think you also want to be honest and avoid exaggerating. So just try to be as straightforward as possible. If the GAL catches you in a lie, that's going to kill your credibility with them. And, they're just not going to trust anything you say. And if they, have the sense that you're exaggerating about things, it's going to do the same thing where it's going to hurt your credibility and make it less likely that the GAL is going to listen to your perspective.
Also, just remember the GAL there is to decide the best interest of the child. So you're keeping your communications child focused. So this isn't your opportunity to just air all your grievances about your co-parent and how annoying they were and awful they were to be married to or to be in a relationship with, and how you hate things about them that have nothing to do with their parenting. Keep it child focused and parenting focused.
And it's not just that stuff is irrelevant. It will hurt your case if you are just trashing the other side, and, the GAL might just think you're out to get the other parent and you're not really focused on your kid and what's best for them. So definitely avoid just trashing the other parent for no reason. Obviously, if you have legitimate concerns, you should bring those up, but try to bring them up in a respectful way without being super angry or, venting, and, just try to, again, just be straightforward and lay out the facts and explain the behavior if there has been inappropriate behavior.
Because the GAL will be analyzing each parent's capacity to support and encourage the relationship with the other parent. That's one of the factors that's sort of always looked at. And so you don't want to be seen as that parent that is so unreasonably filled with rage against the other person that they can't put their feelings aside to focus on what's in the best interest of their kid, and what's the best way to ensure their kid has a good relationship with both parents.
Right. And then finally, just don't coach your kid. Don't try to get them to say certain things to the guardian ad litem. That's a huge no-no. It's just really bad for your kid. If you care about your kid, you don't want to be coaching them and telling them what to say. That can sort of have long-term negative effects on your child if you're putting them into an adult situation that they really shouldn't be in. And it's also just going to really hurt your case if the GAL finds out you've been coaching your kid. And they're very good at sort of sniffing that out. They've been handling probably hundreds of cases as GALs, and they have seen all sorts of inappropriate behavior from parents. So if you're thinking about coaching your kid and telling them what to say to the GAL, just think again and don't do it.
They have a heightened sensitivity to that. They look out for that. So
right. And they'll share that with a judge, and a judge is going to hate that if they find out that you've been coaching your kid and putting them into an adult situation.
Because that's, in fact, you're harming your child when you're doing that.
Right. So I think that's all I've got today for, the role of the guardian ad litem here in Connecticut. Nicole, do you have anything to add?
Just, take it seriously. If a GAL is involved in your case, be serious about it. Let them do their work, let them do their investigation, and then, work with your individual attorney to talk about any concerns you might have about how that evaluation is going.
Right. And I feel like we say this in every episode, but try to reach an agreement in your case. If the GAL makes a recommendation, especially if your attorney sort of feels like it's a reasonable recommendation, it's always best to resolve your case. You'll save yourself a lot of time, money, and headaches if you can reach an agreement and not have to have a trial. So that's going to do it for this week's episode of the Irretrievable Breakdown podcast. I feel like I was worried we were going to be a little bit low energy today. At least I thought I was going to be, but I feel happy with our performance here and our level of energy, Nicole. So
we rallied.
Yes. So as usual, if you have any additional questions, you can contact our office. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well. Thanks for watching, and we will see you next week.